In California, probate court is a very daunting task. The timelines to complete a probate process can be upwards of 1 to 2 years, and that's uncontested, meaning nobody's actually fighting. It's just how long it takes to get through that process. In California, when somebody passes away and they own assets in their own individual name, then those assets that they own have to go through this probate process to be able to be distributed to their heirs or beneficiaries. A lot of times people call us and say, I have a parent that passed away. Can you just transfer that asset to me and my sibling? And we can't, right? It has to go through probate. So probate is the process of filing a petition with the court. It allows then this period of creditors to come forward because they're going to get notice. It's going to be public. And then once all the bills are paid, the assets are gathered, then assets are then distributed. If there's a will, it's according to the will. If there is no will, it's distributed according to what we call intestate succession. Once people understand what probate is and how expensive it is, as an example, if you have an estate worth $500,000, it would cost $26,000 in probate fees to actually put that estate through probate court. And I'm not talking about how much value you have in the house. It's the fair market value, so what it would actually sell for. And a lot of times people, once they understand how expensive probate court is, they want to know how to avoid it. And one of the ways that we can avoid probate court is by completing a trust. A trust allows you to own those assets in your trust, where you are in charge of your trust. And then if something were to happen to you, it is owned in the name of your trust, thereby avoiding having to go through that probate court process. This is going to save a lot of time, a lot of money, a fraction of the cost, and it's going to be private because the trust isn't going to be filed with the probate court, whereas probate is a public process. Another way that people try to avoid going through probate court is using beneficiary designations. And this is a very good strategy depending on your family situation and your financial situation. So let's say that you have some bank accounts, maybe a checking account, a savings account, maybe an investment account. You can put beneficiary designations on all of these accounts. But 2 things to consider with these types of beneficiary designations. 1, what if you get sick? A beneficiary designation only pays out if you actually die. So if you get sick and you have a beneficiary designation, that beneficiary can't access your money to help pay your mortgage or pay your bills or pay any nursing care that you need or hospital costs. So that's why having a trust allows you more flexibility to have them to be able to go in and access those accounts. The second thing is, what are the age of the people that are actually inheriting this money? If you have minor children, you wouldn't want to necessarily put your minor child as a beneficiary on any of these accounts because they can't actually inherit the money. It would still have to go through the court system because they're under the age of 18. So if you're trying to avoid probate, doing a beneficiary designations in these circumstances would not be a good strategy. Having a trust is the way that I would do this because that would allow you the flexibility to put your plan in place. Oftentimes with property, we see a different way to avoid having to go through probate. And this is what we call a joint tenants with right of survivorship. So maybe you own property with your spouse, maybe you own it with a family member or a parent. Title matters when it comes to that property. So how you own title, if it's with joint tenants with right of survivorship, what that means is that when somebody passes away, it automatically gets transferred to that next person after documents have been filed with the county recorder's office. And this is one way to avoid probate court because now that property doesn't have to go through probate court. But where it gets confusing is that title specifically. There's many ways to hold title. And where I see people have issues is they think they have it owned as joint tenants. They just have it owned as John Smith and Jane Smith. Nowhere in there does it actually say as joint tenants with right of survivorship. And this is a really big misconception for people. They think if both people are actually named on title, it automatically means it goes to the other person. And that is not true. What we call this is called tenants in common. And what this means is that if Jane Smith were to die, John Smith does not automatically get her half. Jane Smith's half now has to go through probate to be distributed to her estate. And this is really where confusion comes in. And this is why working with an estate planning attorney is so important, because there are a lot of issues that come up when it comes to title. And this will allow you to understand how is title actually held and what changes need to go into effect so it makes sure that it is actually what you want to occur. One of the other ways that people try to avoid probate court when it comes to real estate is by doing a transfer on death deed, also known as a TOD. This is a document that allows you to basically put a beneficiary designation on your real property. I have seen many issues come down where people do this as a way to not have to actually do an estate plan. And the problem that I've seen is that they don't fill out the form correctly and they record it and then somebody passes away. I had a case specifically where my client was the son of the deceased. He had done the transfer on death deed for his mother, and he did not complete the legal description properly. Therefore, the title company, when he went to go sell the property, would not accept it. We had to file a petition in court and get the judge to have a court order stating that that property was his. And what ended up happening is it ended up taking 8 months to complete. He lost the buyer for the house, and then the market dropped. So this is a perfect example of how not working with an estate planning attorney to try and save money in the beginning led to him spending twice as much as if he would have just paid to do an estate plan in the very beginning. It is so important to work with an estate planning professional to make sure that whatever your wishes are, you can put the legal plans in place and that you do have several different opportunities and strategies that you can do. But at least understanding what all of the ramifications are is so important to make sure that your wishes are known, giving you the peace of mind you deserve.